Zachary McLennan on behalf of the people.
And good morning, Your Honor. James Gilbert here on behalf of Mr. Wargarish, standing to my right.
All right. Morning. Have you had a chance to review the pre-sentence report and recommendations?
We have, Your Honor.
Any additions, corrections from the defense?
Your Honor, the only thing we would ask is to define a little bit on page 2 where it's listed prior record. Under felonies, it says 6. What that is doing is that's counting what Mr. Wargarish.
This isn't just another routine sentencing. This is a case where timing, prior convictions, and one crucial legal distinction could change everything. A defendant already serving time, a record stacked with drug-related offenses, and a courtroom about to debate whether past actions or present charges should carry more weight. But here's the twist. What happens when the most serious conduct isn't technically part of the crime being sentenced? Stay with us, because this judge is about to draw a line that could completely reshape the outcome and raise a bigger question. Should someone be punished for the full story or only the charge in front of the court?
There are 4 felonies that Mr. Wargarish is serving time with over in Alpena currently. We just wanted to point out that those 4 felonies actually took place prior to the activity that happened in this file. So
You mean subsequent or?
no, prior. So this case actually happened before the 4 felonies that he was charged with. Yeah. So yes, those 4 felonies
They are
happened
prior,
subsequent.
okay, they are prior convictions, but you just want me to be aware that
Correct.
the conduct posted.
Exactly.
Gotcha.
And that would be the only correction, Your Honor. Thank you.
Okay, and I'm not going to direct an actual correction. That's just some clarifying information for me, and I appreciate that. The guidelines were scored at 5 to 23 months. Any challenge to this one?
None on our part.
Mr. McLennan, any additions, corrections, or scoring challenges from the people?
Your Honor, a correction. This would be on CFJ-284A, page 13. Number 22 of 23, that's the offense for this case. I believe the offense date and the arrest date should be May 23rd of 2024.
That's this offense?
Yes, Your Honor. I also believe the sentence date should be today, July 20th.
Oh, yeah, that would have been, okay. Yeah, and that seems to be consistent with the offense narrative, Mr. Gilbert?
That is correct.
Okay, so Agent Lesky, if you can make those changes, the offense date and arrest date to May 23rd of 2024, disposition date would be today. All right. Any other changes or guidelines, challenges?
No other additions or corrections. I do have scoring challenges, Your Honor.
Okay, go ahead.
With regard to PRB 5, that was scored at 10 for 3 or 4 misdemeanor convictions. When I review defendant's record, I'm counting at least 8 prior misdemeanor convictions, which would bring that to 20.
All right, Mr. Gilbert, your response?
Well, Your Honor, I would go to the Department of Corrections because I did go and check after the prosecutor brought that up, and they verified that their number was correct. So I was.
Yeah, well, let's see. I'm looking at the adult history. So no security doesn't count. Plate doesn't count. No security doesn't count. MIP doesn't count. No ops doesn't count. Attempted larceny, that's misdemeanor 1. Offense 6 of 23. No ops doesn't count. Number 8 of 23, possession of marijuana, that'd be misdemeanor 2.
Your Honor, I would withdraw that
Okay.
challenge. And then I do have challenges to OB1, aggravated use of a weapon.
Okay.
The offense narrative in this and the police report indicate that defendant possessed a glass bottle. One of the witnesses informed authorities that he threatened to slit the victim's throat. The victim later sort of seemed reluctant to say, but did later state that he did threaten to cut her with the bottle. Did ultimately throw the bottle, hitting her leg, causing a bruise. There is People v. Lang, 25 Mishap 247, that states a glass mug could be counted as a weapon, cutting or stabbing weapon for scoring OV1. So I would argue that OV1, that those facts should be scored at 15 points, Your Honor.
Mr. Gilbert, your response?
Well, I would go back to, and granted, I wasn't prepared for the challenges, and Mr. McClellan did say he was going to challenge some of the OVs just prior to court. He did tell me that. However, I don't believe it meets the requirements, and I agree with the way it is scored, that by it being tossed at her or thrown at her was not a weapon displayed or implied for purposes, and also for the victim was touched by any other type of weapon. I don't believe the actual touching took place to score either 5 or 10 points.
Well, I'm not going to score it for, I think, a slightly different reason. I think it's a McGraw issue. The sentencing offense is possessing methamphetamine in the car. The small amount of methamphetamine that was found during the traffic stop. There's no indication that the possession of methamphetamine occurred, that he used or possessed a weapon during the sentencing offense. So under People v. McGraw, I don't think I can score that conduct. So OBs 1 and 2 will remain at 0 points. Any other scoring challenges from the people?
Your Honor, the only other one then would be OV12, contemporaneous felonious acts. People would argue that the facts just stated with regard to the glass bottle would be a felonious assault that occurred contemporaneously with the sentencing offense, which would bring OV12 to 5 points.
Okay, Mr. Gilbert?
And I guess I would argue that that he pled to the possession, and that no other felonious activity would have taken place pursuant to our plea.
All right, well, the under OV12, it's contemporaneous felonious criminal acts. And here it's alleged that there was one contemporaneous felony act involving a crime against a person by throwing the glass bottle at a person during a threatening and assaultive situation that did occur within 24 hours of the sentencing offense. It's in unchallenged portions of the pre-sentence report. So I find by preponderance of the evidence that there is sufficient basis to score that. OV12 will be scored at 5 points. Any other scoring challenges from the people?
No, Your Honor.
Okay, that would bring the total OVs from 0 to 5 points. This is on class D.
There's no change.
Okay, so that it'd still be a level 1, so the range would still be 5 to 23. Okay. All right, so Mr. Gilbert, anything you want to say on behalf of your client?
Your Honor, I think the young man that's standing before you has actually understood that what has brought him here. And Tim and I have talked prior to today's court via telephone, and then again before today's court. And with his sentencing, he understands that the road that he's on is causing him to be in jail now almost nonstop. While this case was going on, he's been in the Alpena County Jail. And as he went through the things, he was going through his prior record with me, and he's going drug related. I was on meth here. I think he's acknowledging that that path is causing him to have these felonies and all this jail time. While he's been incarcerated, he has been doing counseling, and he has gotten certificates of completion, numerous ones that it appears that he's generally trying to grab a hold and change his life around. I mean, his record is by no means stellar, and he understands that. And I asked him what he's planning on doing once he gets out. And he does seem to have a plan that he's going to go work for family members and try to get his life in order and continue on with a form of sobriety and addressing his drug addictions. And I hope that's accurate. He seems genuine in his resolve to do that. And I would ask the court to follow the recommendation. Thank you.
Do you know when has he been sentenced in the Alpena matters?
Yes, he has.
What date was that on July 21?
Yes, Your Honor.
Just a week ago?
Yes,
What sentence did you get?
I got a year, Your Honor.
Your Honor,
Yeah.
our understanding is that was 2 years probation. with,
I believe 1 year jail.
Okay, yes. All right, Mr. Wargarish, you don't have to tell me anything today, but is there any statement you want to?
I'd just like to apologize to the courts and everybody that cares about me. I could do a lot better than this, and I will.
Okay, thank you. Mr. McLennan, any recommendations from the people?
yes, Your Honor, the plea agreement in this case calls for a county cap. I think under the circumstances, that's a huge benefit to the defendant here. During this case, he did abscond on bond and a bench warrant was issued. This case obviously involves substance abuse issues. He failed the Alpena drug court program in 2016. He has a fairly extensive criminal history. The PSI indicates 6 felonies, 22 misdemeanors. Many of those are traffic offenses, and he's only 30 years old. Just noted was just sentenced to Alpena for another substance abuse case, and given those facts and circumstances, Your Honor, I think the county cap would be appropriate. Thank you.
Thank you. Well, Mr. Wargarish, you do have not a good history as outlined by the prosecutor and in the pre-sentence report. And it sounds like you're fully aware of that. You've previously had the Department of Corrections boot camp program. It sounds like you've had treatment court. So people have tried a lot of different things, which is why then this is a case that, it sounds like there was a lot going on that led to the police contact, but you're not convicted of those things. What you're convicted of, and what I'm sentencing you for today, is possessing a small amount of drugs in a car during a traffic stop. That usually doesn't result in a straddle cell guidance, right? But because of your record, if you jaywalk, you're probably in danger of going to prison, right? Your guidelines are just going to be high no matter what you do. That's not unfair, right? We ought to treat a first-time offender differently than a repeat offender. That seems to make sense. But we do have to also keep in mind what we're sentencing Mr. Wargarish for, and we are sentencing him for possessing a small amount of drugs in the car during a traffic stop. I think the recommendation from the Department of Corrections is within the advisory guidelines. It's within the sentencing agreement of the cap, and it seems proportionate to the circumstances of the offense and the offender. So I'm going to order that you serve 8 months in jail. I'll give you credit for it. Looks like by my count, you're entitled to another 21 days credit. So 172 days credit. And that's the sentence of the court. If you wish to appeal, you can file an application to the Court of Appeals. If you want a lawyer, you have to ask me within 6 months. We're going to hand you a piece of paper explaining those appeal rights and ask you to sign a copy for us. The other one is for you to fill out if you wish to take an appeal. Good luck to you, Mr. Wargarish.
Thank you, Your Honor.
Oh, yeah, and I'm sorry, there's also $68 in state costs, $130 in crime victims assessment, and $350 in.
Adjourn Mr. Frisky sentencing. Mr. Frisky today has expressed some misunderstanding and frankly displeasure with the work that I've done for him. Without going any further, I think he wants to seek the advice of alternate counsel. I would not be comfortable continuing on with the sentencing in this case based on the conversation we have without going into details.
Okay, well, Mr. Frisky, we are here for sentencing, and you knew it was for sentencing. There's a mandatory minimum jail for this offense. So I can't just start having people show up for their sentencing who don't want to go to jail and say, I'm unhappy with my lawyer, kick it down the road. So I'm happy to adjourn it so that you can explore whatever with Mr. Clayton or another counsel, but I'll be remanding you to jail today nonetheless and canceling your bond. So you can't, like, just by saying I'm unhappy, avoid going to jail today. If that means you need another minute to talk to Mr. Clayton, I'm happy to give that to you. But I'm not going to have defendants just show up for their sentencing and say, I'm unhappy, and walk back out that door. Do you understand that?
Yes, Your Honor.
So whatever happens next, you're going through that door. You understand that?
I was misinformed.
I don't care.
Option.
Whatever happens next, you're going through that door and we'll sort it out later. I'm happy to sort it out later, or we can do your sentencing now. Your choice.
Mr. Frisky wants to adjourn sentencing to explore.
Okay, that's fine. And I don't, wouldn't want to put you in a position of going forward when you don't feel comfortable with that either. So we'll continue the sentencing to September 9th so that it's less than the mandatory minimum amount. So it won't prejudice Mr. Frisky at all. We'll continue the sentencing to September 9 at 1:20 p.m. And that's a time you're here anyway, Mr. Clayton, because Mr. Clayton is still attorney of record until anything changes about that. And I am going to order Mr. Frisky's bond to be canceled and remanded to the custody of the Sheboygan County Sheriff until further order of the court. And we'll see you next on September 9th at 1:20 in the afternoon.
Am I supposed to go get that breath thing and bring that in, or?
I'm going to the jail right now.
I'm sure I can get it back.
Yeah. Files 25-7038 and 7039. We've got Miss Fedell present with the lawyer, Mr. Clayton, prosecuting attorney, Ms. Goodrich. All right. And Ms. Goodrich, are you going to later file an amended information?
Yes,
The harboring misdemeanors, what's the maximum penalty on that?
I think that's 93 days.
Is there any fine with that, you know? Ms. Fedell, would you please stand and raise your right hand as best you can? Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God. You can be seated. Ms. Fedell, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have, so I want you to listen carefully. If you have a question, ask it. If you need more time with Mr. Clayton, you just let us know, okay?
Your Honor, that is 93 days and or $500 fine.
Okay. All right, so Ms. Fedell, I have to advise you of the maximum penalty that you could face for these charges. In file 7038, harboring misdemeanors is a misdemeanor punishable by a maximum of 93 days in jail and or a $500 fine. And in file 7039, count 2, possession of methamphetamine is a felony punishable by a maximum of 10 years and or a $15,000 fine. Do you understand the maximum penalty for both of those files?
Yeah.
Are you on probation or parole?
No, Your Honor.
And did you read and understand the rights listed on the advice of rights form?
Yes, sir.
Do you have any questions for me or Mr. Clayton about any of those rights?
No.
Do you understand that if you plead guilty, you give up those rights?
Yes, sir.
Is that what you're choosing to do today?
Yes, sir.
If I accept your plea, you give up any claim that it was caused by promises beyond the plea agreement or by any threats. Do you understand that? Also, when you enter a plea, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. The types of issues you could raise on an appeal after you plead are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, sir.
The plea agreement provides in exchange for your plea to those charges, the prosecutor will dismiss the other charges. And in the felony file, there's a sentence agreement for 7411, which would be a non-public file for probation. And if you successfully complete that probation, it'd be dismissed with no public record of your conviction. Do you understand that agreement?
Yes, Your Honor.
Mr. Clayton, is that a full, fair, and accurate statement of his terms?
It is.
Ms. Goodrich?
Yes.
Ms. Fedell, that sentence agreement for 7411 is not binding on me, meaning I don't have to follow it at sentencing, but if I didn't follow it, you would be allowed to withdraw your plea, not having gotten what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that. If you were to engage in any misconduct between now and your sentencing, say by not showing up for court, absconding on a bond, violating conditions of your bond, or committing new offenses. By that kind of misconduct, you'd be losing the right to withdraw the plea, even if I didn't go along with the sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plea?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 7038, file 7038 to harboring misdemeanors?
Guilty, Your Honor.
How do you wish to plead to the charge in 7039 of possession methamphetamine?
Guilty, Your Honor.
For the harboring misdemeanors, could you assist with the factual basis, Mr. Clan?
Yes, I just have to give them.
It was February 24.
I was more concerned about this thing. Okay. On February 24th of 2025, were you in Sheboygan County, Michigan, state of Michigan?
Yes.
City of Sheboygan?
Yes.
Did you have contact with an officer who was looking for a guy named Joseph Foley?
Yes.
And Joseph Foley had been at your house, correct?
Yes.
Okay. Now, the officer made it clear that the reason he was looking for Mr. Foley is because Mr. Foley had some outstanding warrants because he didn't come to court when he was supposed to, correct?
Correct.
All right. And you didn't help the officer in locating Mr. Foley. You didn't take him to your house and say, here's where he is, right?
No, he wasn't at my house at that point.
At that point, he wasn't, but he prior had been.
Yes.
Okay. All right. And did the officer tell you that he was looking for a count of a felony or misdemeanor?
Yes.
Okay. All right.
Are you satisfied with that factual basis?
I'm set.
Ms. Goodrich?
Yes.
Okay, Ms. Fedell, on April 14th, were you in Sheboygan County
Yes, sir.
and you had some contact with law enforcement?
Yes.
And were you in possession of the controlled substance methamphetamine?
Yes, sir.
Did you know that you were in possession of that substance?
Yes.
Did you have any lawful authority to possess that substance?
No, Your Honor.
Are you satisfied, Mr. Clan? Ms. Goodrich?
Yes.
Mr. Clan, are you aware of any other promises, threats, or inducements?
No.
Do you believe I've complied with the courtroom?
Well,
Ms. Goodrich, do you agree on both matters?
Yes.
All right, Ms. Fedell, I find that your plea is knowingly, understandingly, and voluntarily made. And then that there's a sufficient basis in fact and law to believe you're guilty of those offenses. So I hereby accept your plea in both files. We'll schedule it for sentencing on October 7th at 1 p.m. And you'll have to cooperate with an interview, so a pre-sentence report could be prepared. The parties have any input about what we ought to do in terms of any bonds between now and then?
Your Honor, I would not object to do what we did on the earlier case where her bond is reinstated and we see how she performs on bond between now and sentencing.
Mr. Clan?
I'm in agreement with that. I just want to make a little bit of a record. Brandy, you and I discussed some issues that you have with your urine testing, correct? And now Judge Gauthier has told you that if you have another dilute urine screen, that'd be a bond violation, right?
Correct.
And what did he just tell you about what would happen if you had another bond violation with regards to the sunscreen?
The plea would be taken back.
No, the sunscreen would be taken back.
Correct.
You wouldn't have to follow it, correct?
Correct.
Okay. So now you have an added incentive not to have a dilute urine screen, correct?
Correct.
Okay. I'm satisfied now that I made that clarification on the record.
All right, well, Ms. Fedell, I'm going to reinstate your bond with the same conditions. Whatever issues were going on, I don't want you to talk about that with me now, and I'm not asking you to admit anything about that, but you want to figure out with Mr. Clayune what were the issues so that they don't happen.
Yes, sir.
If the issues were that you were just not able to stop using, there are other ways we can approach that by getting you into either inpatient or outpatient treatment, and we'd be glad to help with that stuff. So whatever the issues are, talk with Mr. Clayton honestly about those, and I think you'd find that we'd want to help with those things. But he's right. If you violate bond between now and the sentencing date, things will not go well for you.
Yes, sir.
Okay, we'll see you back on, and you have to schedule, as soon as you get released, contact the probation department to schedule an interview. It's your responsibility to make sure that happens, okay?
Thank
All right,
you.
anything further from the people?
No, Your Honor.
Defense?
No. thank you.
Okay,
In the end, the court delivers a sentence that reflects both restraint and accountability. 8 months in jail, credit for time served, and additional financial penalties. The judge acknowledges the defendant's long history and repeated opportunities for rehabilitation, but ultimately keeps the focus on the specific offense, possession of a small amount of drugs. This case highlights a powerful legal balance between holding someone accountable for their past and ensuring they're only sentenced for what's legally before the court. And then, just as one case closes, another unfolds, reminding us how quickly circumstances can shift inside a courtroom. So what do you think? Was this sentence fair given the defendant's history? Or should the judge have taken a harder stance? If you found this case as thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.